to stow a case study. And this case is in your material. It's worthy of reading tonight. If you've already read it, put in the chat box that you've already read it. I'm not going to wait too long on that, but it has a lot of complex facts, and I'm going to try to pick out some of the facts that I think affect CPAs the most and to try to give you some takeaways on it. I will note that this came down in July 7, 2020, out of Buncombe County. I consider this to be a landmark case, which is why I included it in the material. It is published. So here are our facts. Date of marriage, October 5, 1996. Date of separation, September 11, 2017. So you have slightly more than a 20-year marriage. There was a marital business, and this marital business was Madison Insurance Group, Inc., an S corporation. Madison Insurance Group placed policies, insurance policies. They placed them for Allstate and 29 other vendors, Allstate and 29 other vendors. But 1/3 of the policies were written with Allstate. And in part, this was because prior to the other 29 vendors were an acquisition. The company started out as an Allstate exclusive vendor and then expanded by an acquisition of another insurance practice. So let's look at what the trial court did, which is very interesting for you CPAs. Admitted the wife's expert, but didn't admit the husband's expert, and both of them were CPAs. CPA was not enough to qualify for business valuation expert in this particular instance. And this is the first case in North Carolina that we've had that has held that. The CPA who testified for wife had another designation as a business valuator. The husband's CPA was designated as an expert in some other financial areas, but just not in the business valuation arena, which take note of that and don't get caught in that trap. So what happened with the value of Madison Insurance Group at trial? The court found $511,212, which is fairly close to the expert's opinion, but not exactly so. And we don't really 100% understand the trial judge's thinking on that, which is probably why the problem. The case got sent back to the trial judge by the Court of Appeals to straighten out and take more testimony, and we'll get to that in just a moment. Essentially, the court adopted the wife's expert's opinion, but not totally. The wife's expert focused on the calculation of goodwill, and let's look at how goodwill was calculated. Goodwill was calculated at 2.45 times gross sales of $217,534. And just the plain math of that is $532,958. That's the math. And of course, the multiplier in this case is the inverse of a capitalization rate. So essentially, that is the capitalization rate or the multiplier as it's presented in this case. Now let's look at where this came from, the 2.45. That is the problem. And that is where the failure comes with winning that position in the Court of Appeals. The wife's expert based it upon published data of all state captive agencies. The 2.45 came out of a magazine that Allstate publishes to its captive insurance agencies about what you can sell the Allstate agencies for. Well, ding, we already know this company Madison has 29 other kinds of insurance companies it represents. It's not an Allstate agency per se. It represents a lot of others. What did the Court of Appeals do? Reversed and remanded for further proceedings. That was not going to be enough. And the rationale is obvious. With 2/3 of the policies being written in other kinds of insurance and only 1/3 Allstate, although that's a dominant market factor, that's just not enough. But let's go on to what else the Court of Appeals said. The Court of Appeals said, referring to this 2.45 multiplier, however, this conclusion failed to consider and reconcile resources and advantages that a captive Allstate insurance agency has, such as buyback provision for prospective seller and other resources to justify and warrant the higher revenue multipliers that over what apply to independent insurance agencies. So that was actually the literal ruling. And they went on the rationale to talk about Revenue Ruling 5960, our old friend. And almost none of these factors were considered or written up. The nature of the business, the economic outlook, book value, earning capacity of the company, dividend paying capacity, goodwill, sale of the stock, none of that is in there. And I will tell you from reading the opinion, and I know this CPA, and I can only guess behind the scenes how everybody got in this situation room, only based it on 1 year's tax return and a little piece of a balance sheet. So here's my takeaways from this. If you're going to testify as a business valuation expert, as a CPA, get a designation, get an ABV or a CVA or another appropriate business valuation credential. Now, here's what I suspect happened. And I will tell you that this is so charming. Oh, can't you just please help me out and give me a value of the business, Mr. CPA, that I can take to mediation? Because we're going to settle this case in mediation. No way will this ever go to trial. And I suspect that husband's CPA and wife's CPA both got caught in they gave something to take to mediation. And then it went to trial because it didn't settle in mediation and they weren't retained or paid. Rule 1 was violated. What's Rule 1? Get your fee up front in family law cases. Don't get caught in these engagements on the fly. Not a really good idea. And then even with the designation, write a proper report, get paid for writing a proper report. If you're going to trial, you need to be paid to do an opinion. Make the report qualify under your certifying agency. Now, in the Stowe case, they only used 1 year's income statement, 1 tax return, maybe they had a second tax return by trial, and a balance sheet. None of this 5-year stuff to analyze was considered. The other takeaway point I haven't mentioned yet is personal financial statements. And CPAs, please help your clients with these, particularly the ones who are going through divorce, because they can kill you. And I think that this really hurt Mr. Stowe's credibility with the trial judge. The husband had turned in a personal financial statement 3 months before the separation. 3, 1, 2, 3. The personal financial statement valued the business at $400,000. And he said it had almost no value at trial. So he became not credible, and the judge just didn't believe anything he had to say. Therein lies a big part of the problem. You don't want to lose your credibility. And I would suspect maybe that Madison agency where they bought the 29 other companies in that acquisition, I bet there was something to do with that $400,000 number he put down on his bank financial statement to do with that acquisition, although that's not clear from the opinion itself. So if you've got questions, put them in the chat box and we'll try to answer them as we're going into our summary. So let's go. We looked at Module 1, alimony modification. And what was the big issue? The big issue is these old agreements and orders. How do we modify them and preserve the deductibility to the payor of the alimony? That usually is the goal. It's usually not the includability for the payee. It could be, though, because she's not going to get any more alimony deductions, and any more IRA deductions. And it's not useful for determination of income. So we covered how to do that. And I think our takeaway principles on modification very clearly were, if you do not change the form of the agreement, stick with whatever form of agreement that you had to start with. If you started with a contract, maintain a contract. If you started with a court order, maintain a court order. And then remember, you elect into the new law post January 1, 2019. And remember, that's an important date, January 1, 2019. It's an election into the law. So carefully read that modification language. Review those 4 examples and talk to an expert about it. If there's a question on a tax return, try to spot those tax returns where they're changing the amount of alimony that they want to include or deduct, and try to find out what's going on there. What's going on with your client? We also covered a module on premarital agreements. And remember, is there a written definition of written agreement in the Internal Revenue Code for purposes of alimony? No, that is not there. There is no definition. So that means it's going to go back under state law. Now, in a premarital agreement, we covered a couple of different issues other than just a general review. And one of those issues is those old premarital agreements out there that say something like, if husband and wife divorce, husband will pay wife $1,000 for half the years of marriage, and husband gets to deduct it. You've got to be very careful. We don't know for sure if there's any way to save that. There might be a way, but if there is a way, you can't change the form of agreement. It's got to be specific enforcement of the premarital agreement itself. And I hope that there would be a tax savings clause in that premarital agreement that would allow a tax-affected amount, such as $700 in that example, to be paid. The other thing that's very clear under the law with regard to premarital agreements is that survivor benefits cannot be waived in a premarital agreement. You gotta be a spouse, and a bride and a groom are not yet a spouse. That is absolutely required for waiver. Now, if I've said anything in the 75 minutes, it's Form 8332 is critical. It seems so simple. Yet, how does this continue to be one of the most litigated issues in the United States tax court? Remember, we talked about the Bethune case, which is just a typical example. I could have picked some other examples. I just thought that that had some points for illustration, and it was a 2020 case. But this is critical, and it keeps being left out. It applies to divorce situations and you want to get those forms and attach it for your clients. Yes, you can present it in an examination, but if you're presenting it in an examination, then that means we already know that there's a problem, right? The government's looking at something, and probably both sides took the dependency exemption. So try to get those things cleared up so that you don't get pulled into that. This is just a little snippet tidbit. The qualifying relative exemption was clarified by a regulation to be $4,300. So that answers that question, one and done. Business valuations. An issue near and dear to my heart is the effect of these subsequent events on COVID. But remember, you've got a savings clause to get an addendum just under North Carolina state divisible property law. And divisible property goes from the date of separation to the date of distribution, and it covers diminution in value. So for all of those restaurants, gymnasiums, you name it, businesses, retail that have had to close because of COVID and the disaster that has been economically, at least in the divorce arena, let's get an addendum to the business valuation and get a more current value that considers COVID. And then finally, we want to talk about STOW, a model for how not to do a business valuation in equitable distribution. And the takeaway is, don't do it on a fly, go get a designation, do a full report. And then finally, look through those old case files, because you now have a statute of limitations of 10 years past the date the tax was assessed to file for innocent spouse status for taxes due. If it's a claim for a refund, you still only have 2 years. But most of the cases I see in the tax court are under the Foxtrot discretionary relief. So if you have questions, this is the time to put them in the chat box as we wind down. And I'll wind down with just a little bit about how the court system, the family law system, has been impacted by COVID. Some people have asked me to comment on that. So child abuse is up 70% in August in Guilford County alone, as reported by the police. Domestic homicide is up 250%. Broken bones are up in X-ray departments. People did not do well being held hostage in their homes in COVID. And it's created a lot of friction, and that has bubbled to the divorce attorneys' phones ringing off. Now, not only are the divorce attorneys' phones ringing off over this, also the courts have been closed. The courts were closed by order and mandated the Supreme Court of North Carolina for 2 months, except for emergency and constitutional ones, such as first appearances. If they arrested you, they couldn't just put you in jail and leave you until COVID was over. But if you have an equitable distribution or an alimony case or need child support, there was no remedy. We were closed for 2 months. In Guilford County, where I have my law firm, the courts have been closed about 8 times over COVID and have been declared a cluster for 2 times at least, and have had extensive cleanings. The temperature checks were being taken to enter the courthouse. Of course, you have to wear a mask to enter the courthouse, and they put up chambers now to walk through that take temperatures somehow by walking through the chamber. So that's the state of the court system as we wind up on Symposium 2020. We have a lot of backlog, and it's not getting better soon. Hopefully we'll have a vaccine soon, not to say anything politically pro or con about whether or not a person should take a vaccine. But family law has been impacted tremendously with COVID, and that's the state of the union on the strategic areas for family law for COVID in 2020. One other thing I will mention is the ability to ask for modifications for decrease for those people who've lost their jobs or have been downsized or have had hours cut back. Some companies have even decreased the amount of pay that they pay employees without having actually terminated them. Those might be eligible for child support decreases and might be eligible for alimony or post-separation support decreases. And of course, if you are the recipient and you've lost your job, you might be eligible for an increase to get a little more spousal support. The problem is it's going to take us quite a while to hear those cases, and I don't know exactly when the court backlog. We are doing cases remotely. I've tried whole trials with lots of financial records via WebEx. WebEx is the platform that the administrative offices of the courts bought and installed for all North Carolina judges in all 100 counties. We are using it in some for calendar calls, some for motion hearings, some for trials. And it's becoming quite comfortable to do things that way. I kind of like it, actually. So that is something I think positively from a technology point of view in the court system and in the family law arena may stick. Again, if you have a question, please put it in the chat box. I'll try to get to as many of the questions as possible, perhaps all of them. And I trust that you have benefited from our hotspots and hot topics in 2020 for the divorce and premarital agreement arena.